parents, it's not just the community, it's not just us as legislators, it's everyone who plays a role in how we fix this. And it's not going to happen overnight. I know some members may suggest that, you know, we can do it just quickly. This is not something that we can do quickly. This is something that will lays the groundwork to ensure that we do have a better education system, a 21st century education system for our children, and that's all within the context of our government's Kids and Learning First plan, which is, again, this is just the beginning of something that we're going to move forward. As I mentioned, you know, we have this framework that will allow us to move forward on this very important issue. One of the things that does talk in this legislation is a proposed amendment will allow and require the school boards to collect the data that's necessary. Now, I know I was the Minister of Education. You know, our government has put a $14 million investment into the in-school program, which, if you hadn't had an opportunity to see yet, it's quite revolutionary. I think many other provinces, I believe, are using it. It's a great tool for administrators and students to follow marking, to behavior, as well as all the other things that need to happen within our school system. So I know that in school, I was in fact there when the minister announced it at Sackville High, probably about a year ago or so. She announced it at Sackville High. I believe all of schools across Nova Scotia will soon be using this tool. And so what's going to be great about this is that now the department will be able to track the type of information that's needed, and that was suggested within the cyberbullying task force, was to allow us to track that those incidences that we see in our school system, and because they are there, Mr. Speaker, those incidents exist. And I think I know when I was down in Yarmouth at Yarmouth High, I spoke with the principal down there. He was a great person. I think actually it was a vice principal. But one of the things he mentioned was that because of the role that things like restorative justice has had in a school like Yarmouth, they have seen a positive turnaround, and that not only within the school context with the students, but as well with staff. In fact, they've seen a decrease in teachers' absences, staff absences, and more than an 85% decrease in absences. So I mean, this is again a positive thing, and I think. And with RJ, as they call it down in Yarmouth, and I think many schools who do have restorative justice, they call it RJ. With RJ, they know that, again, it's a positive reinforcement. You just can't punish children all the time. It's about ensuring that we put it in a context that will allow kids to learn from each other and learn from each other. So again, we know that it's such an important thing to collect that data, and we need to ensure that that this legislation goes forward to ensure that we can track that. We also know that in this legislation, it updates the language in the Education Act, replacing references to a policy on student discipline with references to the Provincial School Code of Conduct policy. This needs to be updated to reflect the more current approach to ensuring students receive the proper supports. And so, again, this will allow all the school boards to have it will actually give the minister the authority to direct school boards to address bullying and cyberbullying. Specifically in their regional codes of conduct. So right now, what we have is each school board has their own student code of conduct. Now we will see a provincial-wide one that will be enforced, which I think, Mr. Speaker, is a positive thing. So with that, Mr. Speaker, I thank the members of the chamber for this opportunity to get up just for a few moments to discuss this very important concern. I know I've heard from constituents of mine who have said that province needs to work with everyone. That's what we're doing. I've also heard from constituents who have called in regards to this this effort, and they've said, look, this is a good first step, and I think that this is exactly what some of the things that we have said. Is laying the foundation. Over the coming weeks and months ahead, we will see more steps forward in this regard. So, Mr. Speaker, thank you very much.
Thank you. If I recognize the minister, it will be to close debate. The Honourable the Minister of Education.
Thank you very much, Mr. Speaker, and I thank the members for their comments. And I'd like to now close this second reading. Thank you.
Thank you. The motion before the House is for second reading on Bill number 30, Promotion of Respectable and Responsible Relationships Act. Is the House ready for the question? All those in favour signify by saying aye. Aye. Against? The motion is carried.
Bill number 30, entitled An Act to Amend Chapter 1 of the Acts of 1995-96, the Education Act, to address bullying by promoting respectful and responsible relationships.
Order that this bill be sent to the Committee on Law Amendments. The Honourable the Deputy Government House Leader.
Thank you, Mr. Speaker. Mr. Speaker, public bills for second reading.
Public bills for second reading.
Please call number 55, the Community Easement Act.
Bill number 55, the Community Easement Act. I now recognize the Honourable the Minister of Natural Resources.
Thank you, Mr. Speaker, and I'm pleased to hear tonight to be able to rise in the second reading of Bill number 55, the Community Easements Act. And Mr. Speaker, this bill fulfills a promise. We promised that in 2009 to establish a mechanism to ensure that communities could preserve land that is important for their traditional economic, tourism, and recreational uses. And legislation was intended to give rural communities a new tool to preserve traditional uses of lands that are valued by the community. And at that time, the urban forest lands were for sale in southwest Nova Scotia, and this government promised to put in place tools to help communities preserve these types of land for their historic and their traditional uses that they hold, uses such as hunting and fishing, recreation, tourism, and forestry. And as part of this commitment, almost immediately after the election, we allocated more than $75 million towards the purchase of lands from large landowners, such as the Irvings in southwest Nova Scotia. And through this process, we've been able to buy back significant parcels of land to be used as a future economic base. So, Mr. Speaker, now we are taking another step to follow through on our election promise. The new Community Easements Act will make it possible for community groups to pay landowners for the right to limit future uses of the land, which would help to preserve such things as working forests, agricultural land, community access to places of interest, scenic views, wetlands, and woodlots. Mr. Speaker, existing Nova Scotia legislation enables protection of land for ecological or heritage values, and the Community Easements Act will preserve land for traditional and economic uses. This act creates a mechanism to allow community groups, municipalities, and the Mi'kmaq to contribute funds and have input into land purchases for community purposes. An easement on land, as most members would be familiar with, is similar to a building restriction, which requires land developers to follow certain rules when proceeding with their developments. The easements proposed in the Community Easements Act will allow community groups to retain interest they value in the land. The easements, you might say, run with the land and remain on the property in the future if it is sold. The buyer may not develop the land in a way that prevents the land use that is protected in the community easement. And there are several situations in which a community easement might be desired. A community easement may be used to ensure that land that is currently used for forestry purposes, for example, continues to be conserved for that purpose in the future. Similarly, a piece of agricultural land which a group or community wants preserved for agricultural purposes could have a community easement placed on it so that it's not lost to urban development in the future. Community easements could also be used in certain situations to establish community recreational access, such as continued use of a traditional access way to a lake or a beach. Mr. Speaker, the Community Easements Act will also be useful to preserve and restore or enhance lands that pertain to archaeology or paleontology or historic values that we have here in our province. When privately held land holdings of interest to the community are being sold, the Mi'kmaq or municipalities or other community groups may be interested in conserving the current use of the land, such as for agriculture or forestry. And the Community Easements Act will provide a mechanism through which the land's use can be maintained. At the same time as the government is introducing this new legislation, we are also amending the Conservation Easements Act. And we'll have more to say about that particular act at a later time. But using this particular act, the Community Easements Act, the Mi'kmaq nonprofit organizations and communities in Nova Scotia that are interested in preserving certain land values or uses of land can work with the landowners to buy an easement at a lower amount than it would cost them if they purchased the land outright. And in that way, Mr. Speaker, it's a more cost-effective way of preserving traditional uses of the land, such as forestry or agriculture, or community access to that land. And by using a community easement, the group that's interested in preserving the traditional uses of a parcel of land has a way to achieve that goal. And the landowner receives a financial benefit. So at the same time, Nova Scotians will also benefit from the continued access to the land. So I think overall, Mr. Speaker, it's very much a win-win scenario. So, Mr. Speaker, that is why government is delivering on this promised piece of legislation today. The legislation and accompanying legislative amendments were developed after public consultation sessions that were held in several communities around our province in 2010. And further focused consultation sessions with particular interested groups were held in early 2012 to gather more input on this particular aspects of the legislation. The Community Easements Act is new legislation that is focused on groups of people who want to acquire community easements. So, Mr. Speaker, drafting this legislation was a cross-government effort. I want to acknowledge the valuable input received from our colleagues in other branches of government, namely the Department of Agriculture, Department of the Environment, Service Nova Scotia and Municipal Relations, Department of Fisheries and Aquaculture, Department of Communities, Culture and Heritage, and also the Office of Aboriginal Affairs. So, Mr. Speaker, in closing, I'm very pleased to be bringing forward this piece of legislation to help make life better for Nova Scotians, and especially those that live in rural areas. And with those few comments, Mr. Speaker, I look forward to hearing the comments from other members on this particular bill. Thank you.
Thank you. Chair now recognizes the Honourable Member for Dartmouth East.
Thank you, Mr. Speaker. I certainly don't dispute the value in providing mechanisms for people to protect land and certainly to protect the use on lands, whether that's agricultural, forestry, and it might even be beach access, I guess, to some extent. There's probably any range of possibilities, or at least so it appears in this act. I do question how different this is than what is already available in law. I am by no means a lawyer, but the day that this was introduced, and certainly in the days following, we've spoken to a number of people who are much more heavily involved in this type of thing, who indicate that everything proposed in this can already be done under existing provincial legislation. That there is no, this certainly creates a specific name for something, but I can I can go to the minister, and if he's got I think he's got a woodlot or something, and if I go to the minister and I say, listen, minister, I'll pay for, I will pay you an amount of money or give you some other kind of consideration so that you will leave that land available for forestry and will continue that use. As far as anybody I've been able to find, there's nothing that prohibits that now. And in fact, I was shown a number of examples where that is already done, in fact, in Nova Scotia, where the ownership has not changed, but an easement for use already exists. It's not called a community easement. I don't know whether it has a specific name or whether it doesn't. And so the question becomes, what exactly is it that this bill does that you can't already do, other than taking a number of different elements of law and putting them into one act, things that already exist? And frankly, in the minister's remarks, I didn't hear any example of something that you can't do now in that respect. So I am willing to accept the fact that maybe there is an element to this act that I am still unaware of, or there is some technicality, but certainly even in questioning his staff through the technical briefings, they also said this is something that can be done now for the most part. And so other than the fact that it now becomes called a community easement, if I understand what the minister is saying correctly, in his remarks just a few minutes ago, and certainly in his statement the other day, he said that this would allow somebody, he used the example of forestry, but I assume it would apply to agriculture, where a organization could go and ask that lands remain in agricultural use or forestry use, and they get basically, well, they would get an easement. It would be called a community easement and be tied to the deed. There appears to be nothing in contract, I assume it would be under contract law at the moment, but there doesn't appear to be anything that prohibits that now. And as I said, I've spoken to a number of people who've negotiated exactly that very thing. We have a number of them, as a matter of fact, along the, I know members are probably tired of hearing about the Shubenacadie Canal, but we have a number of them along the Shubenacadie Waterway where private owners have actually had easements purchased from them for this very purpose. To keep them from being developed and to keep them from having any access from prohibiting public access and from any other use. So as we go through the process, I think that it is incumbent on the minister to try and make clear what is new, because it's being proposed as something that's new, but those people that I've spoken to who are more intimately involved in these sort of activities than I am don't see what's new. They just see an assemblage of things that you could already do before, put in one act and given a fancy name. And if that's the case, that doesn't solve the problem. The minister also has not indicated during estimates or any other time a pool of funding to assist the community groups in achieving this. And so even if it is new, just by virtue of having the ability to do something doesn't mean anybody can actually afford to do it. And so in that respect, the government has effectively downloaded that responsibility onto community groups by standing up and saying, well, you know, we're going to give you the power to do something called a community easement, but we're not going to give you any access to any money to actually be able to afford to do it. Well, there's not really a whole lot of value in that. And so what we appear to have is exactly what we have now, where a community group might go to a landowner, just as the Canal Commission has done in the past, and just has some other, there was a group down the Eastern Shore did it a few years ago, where they went and they wanted to keep land in a certain use, and they paid to have something tied to the deed requiring that. I guess that would be similar to selling, the thing that I think of is that would seem to be similar to like selling air rights. Although it's not for agricultural forestry lands, we have although it's much more common in other cities, we've started to see it now in Halifax where people will pay for air rights. Well, somebody can go to the owner of a property and say, don't build above this height because I want to put an easement, or I don't know what they call it, I don't think they call it an easement, but I want to tie something to the deed that basically prevents you from going above a certain height, and they buy the air rights, which is tied to the deed. And everybody I've spoken to in the past few days, a number of lawyers who have negotiated these sorts of things over the past couple of years, all tell me that they do these things now, and could not see in this bill, on a quick read, what the difference is in this bill, what different element this will provide. Now, I hope it does provide something different, honestly, but I asked the other day, and the staff told me there was nothing different. I asked the minister, when we stood up in the House and we did the ministerial statement, and the response that I asked, and nobody came back with anything different. So we're going on almost a week, and nobody's yet offered anything different that you can't do now. And I think that's important. And I'll reiterate the fact that I also think it's important that you're offering community groups the ability to do something that they may not be able to afford, and in many cases probably can't afford. And so without tying it to a funding pool to support these groups in achieving this, what have you really achieved? So, Mr. Speaker, I will leave it as a hope that there is something that is being missed, because the minister didn't say anything that's new in his statement. So I'm hopeful that as the bill moves forward, that we hear what exactly is new. What is it that prohibits somebody from, or a community group or an organization, negotiating that now? Because anybody I speak to regarding this seems to be able to present another example of this being done before, and maybe not on a regular basis, but I think it's not on a regular basis because nobody has the money to do it. And that gets the second issue with it, which is, what does the government plan to do, if anything, to help people afford it? And frankly, even the landowner, I know that in some cases somebody can go and appeal their assessment on the property saying there's an easement on it. And will that be an option here? Because if it's a restricted use, then hopefully they will be able to appeal their assessment based on, or have their assessment based on whatever that restricted use would be, even if it's one they agree to. And obviously this is an act which requires the two parties to agree to. So maybe the minister or somebody else can provide some clarification. It's gone on a week now, and every bit of information that's come back has said it's exactly what they're now. It's just combined into one act. So, but the minister is suggesting it's keeping a promise, which suggests maybe it's something more than that, but we haven't heard what that more is. Thank you, Mr. Speaker.
Good job. Thank you. I now recognize the Honourable Member for Halifax-Chebucto.
Well, what an interesting and surprising afternoon it has been, Mr. Speaker. I don't know if I can remember when we saw so many government bills go through so quickly in such a short time. I'm not sure if this is because the opposition has decided that they want to set records and they've thought they've found themselves in a race, or whether, surprisingly, they have suddenly found themselves in agreement with the government's agenda. Despite the fact that so many precedents have been set this afternoon.
Order, please. The Honourable Member for Halifax-Chebucto has the floor, and I'm sure he's going to speak on the bill.
He certainly will, Mr. Speaker. Despite the fact that speed has characterized what we have seen so much of this afternoon, I hope members won't object if I take at least a little bit of a leisurely approach to Bill 55, because I do have a few things that I want to observe about it. Perhaps I'll just jump immediately to the point that the honourable member from Dartmouth East raised a moment ago, since he seemed particularly focused on the issue of whether the legislation is necessary at all. He seemed to be under the impression that easements of exactly the kind that are being provided for in this bill are able to be established through the existing legal regime, essentially through contractual arrangements. I have to say that the kind of detailed real estate transactions has not been my area of practice, but I certainly have been involved in it, and some members will know that I take a particular interest in land use and land use planning law since I teach it at the law school. And I want to say to the member that he should really be aware that the problem of easements is a complex area of law, and the examples that he gave where he referred to air rights being negotiated over joining pieces of land, or certain restrictions being negotiated through restrictive covenants on waterways that are somewhat different circumstances. What I think those circumstances would probably have involved would have been adjoining owners who would have some kind of particular and direct interest in what it is that goes on in their neighbor's land. And therefore, they might have even been the original owner of land that had been subdivided. But in any event, some of the technicalities of the law of easements might have been complied with, because there are a lot of technicalities involved. There is often the problem of what's called a dominant and then a servient tenement. And the issue there is that there have to be two pieces of land in close proximity that are serviced, mutually serviced by the existence of the easement. And that isn't always the case here. This legislation deals with situations in which there may well not be adjoining owners of land or common interests that may have split off into other sets. Also, the courts have raised problems about what they call positive and negative easements. And this is another aspect of the technicalities of the laws of easements, and it's very easy to put your foot amiss when it comes to the problem of who is entitled to a valid legal easement. That's why it is that it makes sense to have a clear statutory framework that engages with this issue. It's why it is that it makes sense that if we are interested in establishing community easements, that we have a bill that resolves any of these legal questions. The whole point is to avoid the possibility of lawsuits. We don't want anyone to dispute the validity of one of these easements once negotiated and put in place. It's fairly clear that the issue of how people use their land is of great social importance. Mr. Speaker, most people who go to lawyers for real estate transactions will usually pay a fee to have the lawyer assure them that when they pay the purchase price to the vendor, they end up as the owners of the land. And I have to confess on behalf of the legal profession that in most real estate transactions, this is not a complicated or difficult process, and that it's a fairly routine piece of business, often handled perhaps by a paralegal in the office. And it's not that great care should not be taken in basic real estate transactions. Of course, great care has to be taken, and indeed, purchasers are entitled to rely upon the statement, the certificate that they get from the lawyer that indeed they are the owners of the land after they pay for it. But you know what? I think most purchasers of land are not really all that surprised to get a letter from the lawyer after they purchase land, telling them they really are the owner, along with the mortgage holder, the bank, or the credit union. They're not surprised at all, because that's in fact what they signed up for. And what owners are almost always much more interested in is not that they own the land, but what can they do with it? What uses can they actually put in place on their land? And not only are they interested in what can go on in their land, they want to know what can and cannot go on their neighbor's land and in the community. That's where land use, as differentiated from pure property and ownership law, are distinct, and in my experience, most people are much more interested in knowing, particularly for residential areas, of course, about uses of land. And they want to know if they're restricted in any way. They want to know if their neighbors are restricted in any way, because they look for a certain stability and predictability. And yet at the same time, they also understand that land use can be essentially political in the sense that it can change. I draw this to the members' attention because looking at this statute, you might well ask yourself, as the member for Dartmouth East did, why don't we just do it with easements, which we can do now? I think I've answered that point. We probably can't, without the possibility of setting a foot amiss fairly easily, do it with easements now. But the other thing that people would probably wonder is, well, if we want land to remain agricultural or we want land to remain forest land, why don't we just go to the municipal council and have them zone it? Well, that's part of an answer. That's a possibility. That's an alternative. But you know what? The main thing about zoning at the municipal level is that it can change and does change with a fair bit of frequency. There's something of the hope of stability, particularly in residential neighborhoods, one would hope. People often expect that their land will stay one zoning and over a long period of time, and particularly that their neighbor's land will stay more or less the same zoning over long periods of time. But the reality is that zoning, along with the flexibility of land use planning tools that we now have in the Municipal Government Act and in the HRM Charter, allows for a variety of changes. And this idea of stability can easily be given up. And that's why it is that conservation easements, particularly in the sense of a community conservation easement, make sense. Zoning is not an available alternative. It's not something where you can simply say, let's zone land in an agricultural category, let's zone land in a forestry category, and that'll solve the problem. It won't, simply because it can be changed. This is part of the essence of what goes on at the municipal level, and it's why it is that there has to be a legal structure put in place through laws passed by the province. There are other alternatives that people might think about when they think about the idea of easements. They may think, well, perhaps there are common law easements. Perhaps there's a common law right-of-way that's been established because people have used land in a particular way even though they didn't own it. They may have crossed over the land for a long time. They may believe that somehow a community right over someone else's land has actually come into existence through long use. Well, I have to say again, this is not really an adequate alternative to what it is that the government is proposing here. The idea of common law easements arising is again an area of law that is very restrictive and also very technical. The periods of time are quite long depending on who the owner is. It could be 20 years, 40 years, 60 years, and the conditions that are attached to establishing common law rights-of-way and easements are very difficult to establish in court. And of course, the essence of the matter is that you have to go to court to establish them. And this is again something that's not desirable as a means of neighbors interacting with one another, because if you're in court, it usually means that there's a fight. It usually means there hasn't been agreement. It usually means lots of expense for the parties. It means a long drawn-out business. And of course, the community may win, the community might lose. Even if you could imagine a set of circumstances in which the community members were able to win such a lawsuit and establish a right-of-way, the owner will not have been compensated. The owner won't have been paid anything. If a long-standing usage emerges and can be proven, the detriment or the inhibition on the original owner's land arises and has been established through court action, but no payment is made. So what we've done here is fashion a piece of legislation that provides the opportunity for individuals and groups and communities to negotiate with each other a financial arrangement designed to achieve what the group sees as a desirable result and which becomes acceptable to the owner of the land. And we need a legal framework in order to accomplish that. It's a much better arrangement. It's an arrangement that allows for not just individuals, but community groups to come forward and assert their interest in establishing certain restrictions on the use of land, and they can become permanent. If agreed to, they can become permanent, along with the important fact that there is compensation for the owners. We already have in the law of Nova Scotia certain statutory provisions that allow non-owners to use the lands of other people for certain limited purposes. I have in mind, for example, the hunting and fishing laws, the Angling Act, and I forget what the other name of the other act is, but there are statutes that provide that people can cross the land that is not theirs in order to have access to rivers and streams and lakes for purposes of fishing. There, in many circumstances, is the opportunity for people to hunt on land that isn't posted. Of course, there are restrictions on this. You can't do it on cultivated fields and so on, but there are already these kinds of grants through provincial legislation to community members at large that have the potential to impinge on what people sometimes think of as being their unfettered private property rights. People sometimes think that as the private property owners, they have virtually unlimited rights to do whatever they want with their lands, including exclude others, and including use the land in ways that they believe to be appropriate in their own personal judgment. But that's never been the law. It's just never been the law. Just at its most foundational, there is the law of nuisance. The common law of nuisance has existed for hundreds of years and has established that private owners of land, no matter how clear their title to the land, cannot use their land in ways which causes nuisances for their neighbors. It's always been part of the common law that we recognize community. We recognize the idea of people living together in ways that respect the private ownership and enjoyment of land by others. That's always been the case. That's the case for common law of nuisance, and various statutory regimes have come into play over the last, particularly over the last 100 years, that have put restrictions on private ownership. The tool of easements is a well-recognized one, and before zoning became so common, easements combined with the common law of nuisance were the only tools available to try to influence how people in communities used their land. And we're finding that now it's still a robust, modern tool that we can reinvent without the complexities of triggering possible lawsuits. And that's what this bill does. That's what the minister outlined when he explained to us what the bill was designed to do. We can think of other regimes that are in place. In the United Kingdom, there are what are called right-to-roam laws. These have been in place for about 5 or 6 years now, and essentially it allows non-owners to walk up and down all over the coast of the United Kingdom and to walk across paths that go across the land of other people. They can't light fires, and they can't interfere with crops, and they can't come too close to the home of someone. But if there's open land, there's a right to roam, a legislated right to roam. No Canadian province has that, except we do have in Nova Scotia the hunting and fishing laws, but there's no general right to roam, no general right to ramble, as it's often referred to in the UK. But we are beginning to engage with what are community interests. And one of the ways in which we're engaging with community interests is this bill. So I'm very proud to say that after looking at it, we have found a way to follow through on a specific promise that was made by the government, and to do so in a very innovative way. I look forward to the opportunity to vote for it. Thank you.
The Honourable, the member for Argyle.
Thank you so much, Mr. Speaker, and I'm just going to do a quick, brief comments on this one. I just really want to thank the member opposite for an excellent explanation of this bill, because we've been asking for a week, what does it really do? And all we've gotten from the minister and the department is it's a clarification. And yet here we have a fulsome, thoughtful explanation of the bill, and I want to thank the member.
The Honourable, the member for Halifax Atlantic.
Thank you, Mr. Speaker. There's even more. So. Okay. Actually, I rise with great pleasure to speak on the second reading of the Community Easements Act, and I've been waiting for this for a very long time. Sometimes I felt like a little bit of a spectator, because I've been watching the pressures of increasingly intense land use around some of these areas. And when the member for Dartmouth East wonders whether this achieves anything new, I find it very important to be able to say that this really does achieve something new in Nova Scotia. Nova Scotia has never properly asserted the community right to preserve the rights which communities do establish over time. Nova Scotia has been struggling for this a long, long time. It's got the highest level of private land ownership of any province, and this is a fact of history. It's a frontier province, as I've often said, and it's the first place that Europeans found when they're arriving on the eastern shores of the New World, and it was easy to grant land and to grant it early. The same thing happened in other places along the coast, but Nova Scotia was one of those places which chose as a form of government one in which lands would be assigned, in fact, by the colonial governor, not by one in which lands would be assigned by the township or the community. And we have actually suffered for a long time with that. And Nova Scotia is a place where that tension has existed particularly strongly, and increasingly as we have settlements which are profoundly, settlements and large governments which are profoundly committed to the idea of what we call densification. We've been talking for quite some time about the goal of attaining 12% protected lands. But the criteria here have been solely environmental up to this point. And I've heard the scorn from the opposition when they talk about the government purchasing dirt. And I do take exception to that because of the profound disrespect which it does express for the land on which we all have to live. But I wonder, when the opposition expresses that contempt, whether what they're really talking about is the fact that it's not only dirt that needs to be protected, but some of the other things which we value. Maybe not outright ownership, in fact, at times. We're looking at 12% ownership, but I think we need to 12% protection, but I think we need to look at some of the rationales for this. And I'd like to tell you a little bit about my own background. Perhaps that will help. My parents both came from places not unlike Nova Scotia, but which have been settled for longer than Nova Scotia and have become very, very densely packed. Bermuda, which is where my mother came from, and coastal Massachusetts, which is where my father came from. And both of those are places whose citizens have become exiles from their own land. But those are both places where the common rights are jealously, jealously defended. And I look at that when I go back to Gloucester, or to Rockport specifically. There's a network of paths that lead through the town. There's a network which is protected and which is never, ever contested, of so-called public footpaths and public grounds. Those places were laid out with commons, as was the city of Halifax, as was the town of Lunenburg, as was Annapolis, as was Yarmouth. Not all of those commons were for what is described in the Halifax case as a place for the poor widow to graze her cow, but around Annapolis, it was a place for fishing. Around Yarmouth, it was a place for the gathering of seagrass. Commons take many, many forms, and when development concentrates, it becomes increasingly important to identify just what the Commonwealth is. And the reason I'm getting up to talk about this is because I find myself, as a provincial member of the legislature, increasingly being appealed to by the citizens of a large municipality who are facing what is called as-of-right subdivision. And they're told that large pieces of hereto unoccupied land, essentially unoccupied land in the backlands of this municipality, are in fact subject to as-of-right development because they conform to all the rules, because they conform to zoning. But unfortunately, that's not true. And what has been happening is that the citizens of the areas, and in fact, oftentimes the citizens of a much larger area, are being told that if it conforms to the crude zoning regimen, then there is absolutely nothing which they can say. And when the member for Halifax-Chebucto says that zoning is one tool and that perhaps it is a tool which needs to be re-examined, and we need to look at some of the more subtle shades of easements and the laws of nuisance, which are unfortunately that which come into play when a court has been invoked, when there's trouble because communities have not been heard. I think he's right, and I am so proud to know that this government is looking at the law of easement as a way in which communities, not just adjoining, abutting private landowners, can protect interests. I am dealing at this point with in fact, I have dealt over a number of years with a variety of interests which citizens have in a municipality, and they're confused because they know that these rights have existed, they have gone uncontested for a long time, and all of a sudden, they are not being protected by their local government. So I'm very proud that the provincial government is taking this up. These are people who are looking at unoccupied land, and I describe it as unoccupied because it is obviously fit for subdivision, and I will tell you why this is important in a minute, on which there are intact wetland systems, on which there is drainage, which will, in fact, if obstructed, end up in the flooding of lower-lying properties. Properties which are looked at and which are valued for the view of nature. People look on at the trees, cultural landscapes, shade, light. I am looking right now at a property which is being subdivided as of right, and there are people living in buildings who will never see the light of day again inside their homes. We know that there is no common law right to light, but that could be created through these easements. There are people who will be living in canyons, and there are patches of grass which are marked for residents only between those apartment buildings and in those canyons. So you may walk on the paved street. But there are other rights, the rights to pass and repass, and there are the views of cultural landscapes and of built heritage, in fact, which are things which do contribute to the quality of life in our province, but they have not been recognized as value when, in fact, lands are simply sold off without inspection as to what has been, quite without harm to the landowner, enjoyed. I believe these things give social context, and they provide a real and a significant buffer between citizens. When I see the subdivision as of right, and I see that citizens are not told to express, or not permitted to express any value whatsoever on what they place any value or express any opinion on what is going to be lost when the property is densified to its utmost, as is referred to, lot yield, then I am very, very sorry to know that, in fact, there is essentially a tithe being paid. These properties, and when I say tithe, I think all of us know the word tithe, which means a tenth. And perhaps it's no coincidence that the Municipal Government Act allows for land use bylaws, which are quite common throughout this province, which permit, on subdivision, a municipality to request an up to 10% what is called open space dedication. Sometimes it's referred to as a parkland dedication. And it has become, in some areas, pardon me? In some places, it's been referred to as a recreation allowance. And I had the unfortunate experience the other day of listening to a group of citizens who are attempting to, as they would put it, protect an area of land which does give open space in a fairly densely settled area. It is a wetland. It's much valued as the peeper pond, as they say. Children have walked here. Old people walk here. It's interesting because it actually, coincidentally, it happens to be used not only by the primary school children of a local school as a place to investigate tadpoles, but a place which is visited by the oldest citizens of the area who are living in a nursing home. They don't actually know each other, except that they encounter each other in this small, undeveloped area with its paths, its traversing paths. And it's been known for 40 years or more, and that's only as long as I've known it. So many people come and say, well, what has happened? Permission has been given for this to be infilled, and that permission has been given as of right. Now, what happens is that compensation is given, but unfortunately the municipality is taking this compensation and it's not using that compensation as open space. It has said this land is not useful and it's not usable. And the residents of the area on all sides are begging for this land to be left, a piece of that land, not even the whole tenth of that land, but a scrap of land, which is essentially unusable because it is a wetland, instead of cash in hand poured into a recreation facility, which may or may not be used by the 5-year-olds and is probably not going to be used by the 85-year-olds. And it may or may not be in the same area. It may be on the other side of a jurisdiction as large as Prince Edward Island, which we know as the Halifax Regional Municipality. This is really, really unfortunate. But the Community Easements Act, the community easement I see as a possible tool, because the 5-year-olds don't have a property interest and the residents of the nursing home don't have a property interest, but there is a community, and there can be a community which can hold that easement, and the value of that easement can, in fact, I see that it could go to that neighborhood or to another group representing that neighborhood. And that community easement, which might be nothing more than the commitment that this piece of land will remain untouched in this subdivision, is something of huge value, and it is usable land. It is usable to this community. And more importantly, in some ways, is the sense that the members of this community have in fact been able to have a voice, and that what has been valued in their area actually is something which their government has valued. There are conservation easements which have been around for a long time, but they're not the same as community easements, because community easements also talk about aesthetic values. We've got cultural landscapes, and you may be aware, or Mr. Speaker, you may or may not be aware, but many members of this House will be aware that as development pressures intensify, sometimes older landscapes, which do form a part of the cultural stock and which are matters of fondness, are subject to pressures for replacement and greater densification. But there's distress around that, and it's interesting to see the breadth of that distress, and it's interesting to see the lengths to which people will go in their attempts to, in fact, preserve what they value. And a community easement is a way in which something valued by a community can be preserved. I'm looking at other areas which are going to be subject to development, and other values which are going to be very difficult to talk about in terms of conservation easements. I've spoken before, I think, about the man above me with his muniments in hand, the Honourable Joseph Howe. There's a piece of property near me which hasn't really been talked about very much, but it certainly will be subject to as-of-right subdivision without a word. And there are people who do value the fact that Howe's Rock is the place where Joseph Howe used to like to spend sunny afternoons. And I think it's reasonable to say that a lot of other people have enjoyed spending similar sunny afternoons there over the last 175 years. When somebody told me today that people had simply been, the public had been trespassing on her land for 125 years, actually it was not her land for 125 years, but trespassing on this marked path for 125 years, I was surprised, because if there are really trespassers, if there's not a sense that there is something of public value, then why not defend that? Certainly the same property owner had defended other things, had said, no, you're not welcome here. But this has become public. And when a local government says, this is going to be subdivided, this is now all going to become private property, and what has been public property is not going to be available in any way, we need a mechanism for the public to speak, for the community to speak, and to say, we value this, and this is a part of this value. We actually don't necessarily want this view, this path, this swimming place, or this marsh to be turned into cash for another exercise machine in a recreation center. No disrespect to the exercise machines, but there are many of us who actually do, in fact, derive other values from the landscape around us, from the land around us. Another place this has arisen in many occasions, and I would feel very sad if it were necessary to, in fact, protect this doubly, but perhaps we do need to protect these things doubly here, is the issue of infilling on salt water, the protection of the intertidal zone, the right to pass and repass. There are a number of people in Nova Scotia recently who have taken to creating land across the intertidal zone and thereby creating public land out of what has traditionally been creating private land out of what has traditionally been the place for the public to pass and repass. And as my colleague mentioned, in the United Kingdom, the right to roam, which accounts for all of the intertidal areas around the densely developed area known as England, which is in fact the root stock of the Nova Scotia law. So if in fact we have to create another piece of legislation to protect what should be protected by the common law, then I think we have done something incredibly valuable here. This is a fundamental assertion of values which can be shared, of benefits that can be shared. And I sincerely hope that this opens a door to the preservation of the Commonwealth and an understanding that private property doesn't have to mean absolute ownership, and it doesn't have to mean battles between the hard edges of neighbors whose governments have not assisted. I would never want to be part of such a government, and I'm proud to say that I have not been. Thank you very much.
If I recognize the minister, it will be to close debate. The Honourable, the Minister of Natural Resources.
Thank you, Mr. Speaker, and I want to thank all the honourable members for their interventions and their input on this important bill. And Bill number 55, I think I've already moved a second reading, but if necessary, I'll do that again, and I just look forward to it moving along to the law amendment stage. Thank you, Mr. Speaker.
Thank you. The motion before the host is for second reading of Bill number 55, the Community Easements Act. Is the host ready for the question? All those in favor signify by saying aye. Aye. Against? Motion is carried.
Bill number 55, entitled An Act Respecting Community Easements.
Move that bill now be sent to the Committee on Law Amendments. The Honourable, the Deputy Government House Leader.
Thank you, Mr. Speaker. Public bills for second reading.
Public bills for second reading.
Please call Bill number 32, the Securities Act.
Bill number 32, the Securities Act. Chair now recognizes the Honourable, the Minister of Finance.
Thank you, Mr. Speaker. I move second reading of Bill number 32, an act to amend the Securities Act. The act on its face may seem complex and a little bit intimidating, so I do want to offer a few words of context for the benefit of the House. Securities regulation is the responsibility of individual provinces, but of course capital markets are national and international in nature, and it is important that they function well from both a national and international perspective. Now, Nova Scotia is a member of the Canadian Securities Administrators, known as the CSA. The CSA is a voluntary umbrella organization of Canada's provincial and territorial securities regulators whose objective is to improve, coordinate, and harmonize regulation of Canadian capital markets. As a member, Nova Scotia has committed to making necessary changes to our securities regulations that strengthen protections across Canada. These changes, Mr. Speaker, are the result of considerable research and national consultation. Every province and territory is represented on this body, and many of the changes found in the legislation have already been adopted or are in the process of being adopted by the other provinces. These amendments to the Securities Act ensure securities legislation remains modern, up-to-date, and harmonized with other Canadian jurisdictions because, of course, Mr. Speaker, some people would like securities to be federally regulated, but that is contrary to our Constitution, as the Supreme Court of Canada recently ruled. And so, since it is within the jurisdiction of the 10 provinces and the 3 territories, we are making our very best efforts to have a facsimile, as it were, of a national securities regulation. And we have the system called the passport system that really works quite remarkably well. But the passport system requires a high degree of harmonization among the jurisdictions, which is why we've had a series of securities bills in front of this House over the last 5 or 6 years, each one carefully thought through on a national level and then passed in all of the passport provinces. The point of sale disclosure project, which is intended to improve disclosure provided to investors or potential investors at the point of sale of investment fund products, is targeted for implementation across Canada on July 1st, 2012. That is why the bill is in front of the House now. In addition, there are other provisions which require updating to ensure they are harmonized with recent developments in other jurisdictions. While these amendments are not as time sensitive, it is important to maintain that high degree of harmonization of the securities regulatory regime. Through the CSA, we are ensuring that Nova Scotia's investors are protected by the same securities laws that are in place elsewhere in Canada. As well, Mr. Speaker, the proposed investor protection initiatives will provide the Nova Scotia Securities Commission with greater flexibility and effectiveness in enforcing these laws. With that, Mr. Speaker, I again move second reading of Bill number 32. Thank you.
We now recognize the member for Halifax Clayton Park.
Thank you very much, Mr. Speaker, and it's a pleasure for me to say a few words on Bill 32, which is before us this evening, this being another amendment to the Securities Act. And although the minister mentioned the fact that it was not possible to create a single securities commission nationally, I think many provinces were in favor of it. I believe there was just 1 or 2 that were not. So it's sort of unfortunate because Nova Scotia is a small jurisdiction and some are even smaller. So I think that it is something that would be a savings all the way across the board to have one if we're going to harmonize all of our laws. But in the absence of the ability to do that, I think it's the right thing to do, that we harmonize the language and the effect of each of these amendments. I know that in discussing the previous bill, when we were talking on easements, the Speaker offered a little bit of personal insight into her interest in the Easement Act. And I'm very interested in things to do with securities because I was raised by a mother who was a stockbroker. Nowadays, Mr. Speaker, you would call that an investment advisor, but in those days it was a stockbroker, and it gives me an opportunity to say that she was the first woman in Calgary to do that job. So I'm very proud of that. Yes. Yeah. In fact, we believe maybe the first in Alberta, but definitely the first in Calgary, and there were no women in that profession at all. You know, certainly when I went into her office for many years, she was the only one, and it was not only a masculine area, it was in Alberta. So you can imagine the office where they sold these securities. It had a ticker tape, the like little tape thing that went across with all of the symbols of the different stocks, and men came in, mostly like old ranchers and farmers and things, came in and sat in almost pews at the front of that office and watched the ticker tape going by. And they practically had spittoons in the corner. It was just like that in the first office. It was really quite interesting. And all of the stockbrokers sat behind, and all they had was a telephone and a phone book, basically, to call and get clients and meet people over the phone, and no support whatsoever in terms of any help. It was 100% commission, so you had to have the courage to get involved and know your stuff and get out there and sell some stocks. Otherwise, you didn't make a thing. So I know nowadays, most of the time when you join an investment firm, you're given a year and a half or so where you have a salary and there's a little bit of help to get you started. But it was much harder, much more risky, really, to take on a job like that. And she said for quite a while, she made barely enough to pay the parking and the babysitters. So it wasn't easy at all. That was 1968. So anyway, as I say, I was raised in a house where there's lots of talk about stocks and about ethical investing and all of the issues that go on around that, and anything that is improving I think the consumer protection and I guess harmonization, as the minister said, across the board with different jurisdictions is very important. I know he mentioned the point of sale disclosure, which I think is something when we talk about protecting people, ensuring that there's ethical behavior among all the people that are involved in security sales, and through that giving people the right information and ensuring they're well protected. So really with that, when I went through the explanatory notes for the bill, I saw a lot of things like it takes out gender-based language. So we now have gender-neutral language. A couple of instances where that's mentioned in the explanatory notes. Again, changing certain definitions, and that is things like changing chairman and replacing it with the word chair. So a number of the notes, although there's quite a few, there's 24 clauses that are discussed. Most of them are of that nature. Some rule changes and pretty basic changes overall. And they are, as the minister said, one in a series of amendments that we've passed here at the legislature over the last number of years. So this is a trend that I think will continue until all of the work is done. And the minister mentioned that some things are going to come into effect this July. So I think we're moving, hopefully we've even completed it, but we're certainly moving in the direction of having all of this harmonized across the board. And Mr. Speaker, we have no objections here from the Liberal Party to these amendments. Thank you.
The Honourable, the member from Argyll.
Thank you very much, Mr. Speaker, and I thank the Minister for bringing this bill forward. Of course, as we move towards harmonization of any piece of information across Canada, I think is a good thing, especially when it comes to securities. But ultimately, we're looking forward to, of course, the next steps in the legislative process, which, of course, is to send it off to law amendments, listening to maybe people with some questions about it or concerns. But it looks like the minister has done his homework on this one. Mr. Speaker, ultimately, again, this issue seems to have had its work done. This one seems to have the work done on it. Unlike a lot of the bills that have come forward here tonight, which of course have very little substance. This one does have substance, and one I think that is worthy to move on. We look forward to further discussion on this one in the future. Thank you very much, Mr. Speaker.
Thank you. Question. If I recognize the minister, it will be to close debate.
I'd like to thank the members opposite for their comments, especially the personal comments of the member from Halifax Clayton Park. Very interesting family connection to the industry. And with that, I move second reading of Bill 32. Thank you.
The motion before the House. The motion before the House is for second reading of Bill number 32, the Securities Act. Is the House ready for the question? All those in favor signify by saying aye. Aye. Against? Motion is carried.
Bill number 32, entitled an Act to amend Chapter 418 of the Revised Statutes 1989, the Securities Act.
Order that this bill be sent to the Committee on Law Amendments. The Honourable, the Deputy Government House Leader.
Thank you, Mr. Speaker. Mr. Speaker, that concludes the government business for today. Request that the House do rise to meet again tomorrow at 12 noon. The House hours to be from 12 noon to 10 p.m. The orders of the day following daily routine. We will be calling public bills for second reading. Bills number 34, 37, 39, 41, 52, 59, 61, and 65. Thank you, Mr. Speaker.
The motion before the host is that we now do rise and meet again tomorrow from the hours of 12 noon to 10 o'clock. Is the host ready for the question? All those in favor signify by saying aye. Aye. Against? The motion is carried. We are now adjourned.